first speaker today is Valerie Lovelace, and I'm going to take the chance of being just a talking head here because I'm very concerned never to introduce somebody without the correct facts. So I'm going to read you what is in our newsletter about Val. She's the State Leadership Incubator Manager of Death with Dignity. Val collaborates with state grassroots leaders and activists, providing mentoring and training to support their efforts in implementing the Death with Dignity law. She organized and led Maine's grassroots success in its passage. Please note, FCA Maine is not affiliated with Death with Dignity and takes no stand for or against its mission. FCA Maine board feels it is important for our membership to know what this movement stands for and encourages members to make their own personal decisions about this important issue. Val, welcome to our annual event, and it is a pleasure to have you with us.
Thanks so much, Anthony, and it's a pleasure to be here and to see so many familiar faces. Chuck and Nancy McNally, who just got off, Rochelle, Allison. I miss you guys. I have many fond memories of working on the board with you all, and I look forward to future fond memories in our relationships if and when the pandemic settles down and the world survives. So. Thanks for the introduction. I'll be speaking directly to the law here in Maine primarily. We'll go through a little bit of information about, what exactly does Death with Dignity mean? What is that law about here in the United States? And then at the end, I'll have time for questions from anyone. I have recently stepped into a new role with the National Center. I mean, one of the amazing things that came out of our campaign after the law passed is I was offered a position with the National Center and actually get paid to do what I love, which is a rarity, I think. But I am now the director of statewide campaigns for that organization, and our work is really to advocate in states and help grassroots organizations pass laws either through their legislature or via citizens initiative if there is momentum for that. So I'm going to share my screen to you. So we'll talk today about the Death with Dignity law itself and how it works. And as soon as I can get my controls working here, there we go. So today we'll define what the term death with dignity means in the context of United States legal and medical practice. It's important that I underscore that because other countries have different laws than we do. So it doesn't help the conversation here in the US to talk about what Canada's law is like or what the Netherlands law is like. So we'll maintain the context of the United States legal and medical practice. We'll talk about some other terminology that's used in relation to these laws. And then I'll go through very quickly what the legal and medical requirements are if a patient wants to qualify under the Maine Death with Dignity Act. So in the United States, a death with dignity law means the legal prescribing of a single dose of medication that a patient may ingest on their own without assistance. That's really important to keep in mind. Some people have the impression that, they can write this into their advance directive, and then, if they can't make medical decisions for themselves at some point in the future, that their agent can choose this option for them, and that is untrue. This is totally in control of the terminally ill patient, and they have to ingest the medication on their own without assistance. So medication comes in a single dose in a lethal quantity. It's written by a consenting physician at the formal request of a qualified terminally ill adult patient, and we'll talk about what that qualification requirement is. And then I just want to underscore that this is for age 18 and older terminally ill patients who qualify. And it follows a very specific, legally defined, safeguarded standard of care process. So the law is actually what folks don't understand about the law is it's a codified medical standard of care. It outlines the process by which patients practice by which physicians practice with their patients to meet the request of a hastened death if a patient is wanting to choose that. Here in the United States, the only exception is the state of Montana. They have a Supreme Court decision, state Supreme Court decision in their state that basically says the conversations between physicians and patients are private, and there are no statutes in our state that would prevent a physician from supporting a patient decision of this kind. So they don't actually have a law. They simply have the blessings of the state that there are no laws that would prevent the practice. So currently, aid in dying is legal in 10 U.S. jurisdictions. Initially, it was passed in Oregon in 1994. It immediately was upheld by a federal legal challenge that was not cleared until 1997. What the federal government tried to do is prohibit the use of the medications for aid in dying. It was a 3-year skirmish. They lost that battle. And in the end, the Oregon legislature decided to put the question to the voters again. And actually, there was a lot of momentum hoping the voters would overturn it, but they passed it by an even greater margin. So that law went into effect in 1997. That was followed by the Initiative 1000 in the state of Washington that was headed up by a woman named Nancy Najilski. If any of you have watched the film How to Die in Oregon, Nancy is in that film with the story of her husband who died with a glioblastoma brain tumor. That was followed by the court decision in Montana. Montana is the only state that has had that court decision. Every other state that has attempted to gain access to medical aid in dying through the courts has failed. The state of Vermont made history in 2013 when they passed their legislation by legislative action rather than citizen vote, and that was after a 10-year campaign. State of California followed very quickly in 2015. Something interesting happened between 2013 and 2015. Some of you may remember the story of a young woman, Brittany Menard. She was a California resident, 29 years old, who found out in 2020, I can't remember exactly when, I think it was 2012 or 2013, that she, right after her honeymoon, found out she had a rapidly growing glioblastoma. At that time, the California voters had just narrowly voted down an attempt to pass a law. So Brittany decided to move to Oregon with her family, establish residency and medical care, and she died in 2014 using the law. The anniversary of her death was November 1st. Her mother and her husband both became advocates of the law, and they work with national organizations now to tell Brittany's story and help people understand why the law is necessary for some folks. Brittany's death was actually was a catalyst that really brought this conversation even more to the forefront than previously, because for the first time people were witnessing a 29-year-old young vital woman with a brain tumor whose trajectory to death was excruciating. And the recognition that when you have a terminal illness with a very healthy body, sometimes dying is pretty incredibly difficult. So following her death, the California legislature actually ran a bill and was able to pass that in 2015. And I think it's largely due to the efforts of Brittany's advocacy before she died and the advocacy of her mom and her husband. Colorado followed in 2016 with a citizens initiative that passed by, I believe it was 67%. The state of Washington, D.C. passed by a city council order in 2017. Hawaii passed by legislative effort in 2018. And then for the first time in history, 2 states passed legislation in the same year, and that was New Jersey and Maine. During the 2020 session, there were over 20 active bills, but where everything has been really, was stalled out by the COVID crisis and the need for legislatures really to pivot their work towards emergency support in their states. So all of those bills were set aside because they are routine legislation. Overall, since 1997 through the end of 2019, there's been approximately 3,900 deaths nationwide through medical aid in dying. So you see, it's a tiny population. In Oregon, it's about 0.4% of the total deaths per year are by this medication. We've had one death in Maine in 2019. On the day our law went into effect, a patient contacted me and said, my doctors are on board and we're ready to go, and we don't know what to do. And so it was that, for me, is when it became very real that the law had passed and that we had changed the history of Maine by making it possible to have additional end-of-life options that this patient was able to avail himself to. He had ALS, and he died the day after Thanksgiving in 2019. On the day our law went into effect, September 19th, a major healthcare network, Maine Health with Midcoast Parkview, publicly announced they would be supporting patient decisions. I think we're the first state of all of the states that had that happen. Maine Health had their policy in place by about mid-January of this year. And also New England Cancer Specialists are supportive. So this is a really large healthcare network. Northern Light and Maine Health have also joined with supportive policies. Their policies went into effect sometime around April. And then there's a smattering of other independent organizations and some hospice organizations that also have supportive policy. We're getting a little bit of feedback, so if I could just ask folks to mute if they are unmuted. What it means to have a supportive policy is that the provider network basically states that physicians may participate to support patient decisions if they choose to do so. There is no mandate for a physician to participate. A non-supportive policy would be where a hospital or care provider or a care provider's office would say, we're not supporting patient decisions using the law. So they're not participating in the practice of medical aid in dying. Oops, I think I might have jumped ahead. No. So some terms that you will hear in relation to medical aid in dying. Death with dignity is the term that was coined back when the law went into effect in Oregon. That's tends to be the term that I use because it's the most understood one. You'll also see medical assistance or medical aid in dying with the acronym MAID being used, and physician aid in dying or PAD. I often see that term in like professional journal articles, the Journal of Medicine or nursing journals. Inappropriate terms are suicide and assisted suicide, and I'll explain why that is. Physician assisted suicide is also inappropriate. And euthanasia and mercy killing are inappropriate. Euthanasia is an entirely different thing than medical aid in dying. As under medical aid in dying, the patient is requesting the medication. They have to remain, their decision-making ability has to be intact, and they themselves are ingesting the medication if and when they choose as their death approaches. Whereas euthanasia is an act of someone else causing the death of an individual. So euthanasia is what we do with our pets when they're at the end of their lives, and generally would involve the injection or insertion of some type of medication to bring about death. So in the simplest of terms, these laws do two things here in the United States. It codifies the process and the standard of care by defining who can access the law and under exactly what circumstances. And then it distinguishes or insulates and safeguards that kind of death, which is an expected death of a terminally ill person, just like a hospice death, from what I call that kind of death, or deaths that are defined by other statutes in the states as crimes or as suicides. And that is the pragmatic reason why this is not considered assisted suicide. For Maine actually has an assisted suicide law that prohibits the assistance of one person to another to help them end their life outside of the context of this law. Um, so from a very pragmatic standpoint, when someone is dying under the Maine Death with Dignity Act, it's an expected death. Everybody knows that it's going to be happening, and there are things that don't have to happen with that kind of death. For instance, you don't have to call the coroner. You don't have to call anybody because nobody witnessed it. You don't have to have an emergency intervention because somebody with a mental illness is wanting to end their life. All of those requirements that are emergency responses to suicide or an attempted murder don't happen with this kind of death. And so what this law does is it simply says this kind of death is not those other kinds of deaths. It's a different kind of death. The other thing that it does from a pragmatic standpoint is it protects the patient's life insurance policy, if they have one, that has a suicide clause, because it's not a suicide. It's just very simple that the suicide clause in a life insurance policy could never be enacted to prohibit payment to that person's family because it's not a suicide. It is not legally or medically defined as such. So patients must be an adult here in Maine. That means 18 years of age or older, be a resident of Maine. Maine has a laundry list of all of the ways you can assert that you are a resident in order to register for voting. And this law has that same list of things. It's really up to the physician to review what the patient is presenting as their evidence of residency. And if the physician is comfortable with that information, it could be an electric bill with their name and address on it. It could be a driver's license. It could even be an expired driver's license with some other evidence. But as long as the physician is comfortable that that individual is actually a resident of Maine, then the qualification process can move forward. They have to be diagnosed with a terminal illness and have a 6-month or less prognosis. All of these laws in the United States have that requirement. And the reason for that is that's essentially the Medicare requirement that indicates you are eligible for hospice. So it's the medical model we have to work within. The diagnosis and the prognosis has to be confirmed medically by 2 physicians. The patient has to have and maintain the capacity to make informed decisions or to act on their own behalf. So this automatically disqualifies any patient who is suffering with dementia. And if there is a question by either physician that the patient is having difficulty making decisions, they would be referred for a mental health evaluation to determine the capacity. So sometimes it's possible, like even with a neurological disease such as Parkinson's or ALS, sometimes those patients can be cognitively affected, either temporarily or permanently. Patients who are dehydrated, for instance, may have a little bit of trouble, or patients who are heavily medicated may have a little bit of trouble. So if the 2 physicians have concerns and they have their own type of assessment tools to determine if someone has capacity, they will then refer for a deeper evaluation just to make sure that, if there's something that can be adjusted with the patient to eliminate a temporary problem, they can do that. But if it does look like the trajectory is more towards a dementia-related problem that really significantly impairs decision-making, then that patient would be disqualified to proceed any further. And there's, I could talk for hours on all of the ethical reasons around that, but just suffice to say that the difference between medical aid in dying and moving to a scenario of euthanasia, which is where someone else makes the decision for that patient, crosses so many avenues of ethical questions and law and medical boundaries that it's just not an easy policy leap to go from one to the other. I know that's frustrating for a lot of people. One of the complaints I hear most often is, what about dementia? What if I don't want to live 15 years with that disease before my body expires. And unfortunately, these laws just cannot address that scenario. There are a lot of other options that folks with dementia can consider as their disease progresses, but this is not one of them. So what the process looks like, just in terms of from the initiated formal request to the receipt of the medication, if everything goes like clockwork, the first formal verbal request is submitted to a physician, and that's like, you know, you're sitting there with your doctor and he or she advises you, you know, we've been treating your cancer for a very long time, and I'm sorry to tell you, we are at a point now where you're running out of treatment options, and perhaps you'll want to be considering hospice and palliative care, because it looks like your prognosis is within 6 months. So, you know, that request might look like something like, you know, doc, you've just given me some really bad news, and I want you to know I want to pursue qualifying under the Maine Death with Dignity Act. So that's the first formal verbal request. Terminally ill, 6-month prognosis, adult with mental health capacity, telling the physician, this is what I want. Within the following 15-day period, a second verbal request has to be made, and also a written request submitted. The written request is witnessed by 2 people for the patient that are basically saying, I watched this patient sign that paper, and to the best of my knowledge, they didn't do that under duress. And that gives the physician a formal written document to put in the patient's medical record that they do indeed want to pursue this option. If by day 15 to 17, everything is in order, it's important to note, upon receipt of that written request, the physician has to wait an additional 48 hours before filling the prescription. So if you're the patient and you give your doc the written request on day 15, you're going to have an additional 2-day wait before that prescription can be written. There's nothing that says you can't submit your written request with your first formal verbal request, or you can submit it anytime within that 15-day period. If you wait until after the 15-day period, let's say it's 2 weeks later that you get that written request to your physician, you're going to wait an additional 48 hours before that prescription can actually be written. This gives your physician plenty of time to, you know, check, cross the T's and dot the I's and make sure everything is in order before they write the prescription. So again, let's say you don't wait that 2 weeks and you submitted your request prior to day 15. And if everything is in order, so you have capacity, the 2 physicians confirm your prognosis and your terminal illness, and you're able to physically take the medication on your own, then it's about a 5-day wait, from what I understand here in the state of Maine, from the time the pharmacy receives the prescription until they can dispense it, because they have to order and compound the components for the medication. Medication comes in 1 dose, but it has 4 components to it that have to be compounded. This is not like an off-the-shelf kind of medication. So the dose, which it is, I could answer some questions about what it is if you have them, but it's taken if the patient chooses and when the patient chooses, as their death becomes imminent. A lot of people have the impression that, you know, a patient at 6 months with a terminal illness is going to get their prescription and take it right away, and that is not the case. Patients, as long as they are receiving good hospice and palliative care, which is totally compatible with this, will want to enjoy the high quality of life for as long as they possibly can before it looks like they are imminently dying. And then they will choose to use their medication, or may choose not to if they're being kept comfortable and everything is going okay with hospice and palliative care. Many patients say they feel better just knowing they have it as plan B if things start going south. I have a good friend of mine who is terminally ill, who has qualified for this medication. And she told me it was such a relief to have it, just to know that if things got as bad as she imagined they could get, and she's been told they might get, that's her plan B. That's, her backup. So a physician is required to counsel the patient, to notify their family of their decision to not take the medication when they're alone, and also to not take it in a public place. You can go to mainedeathwithdignity.org if you're interested in reading the details of the law. Everything is in that, but I won't go into all the legalese right here. So there is a lot of misinformation available out there floating around still here in Maine about how the process works, about the cost of the medication or the type of medications being used, about whether the law is fully implemented or not, and about whether providers or facilities can or do participate. So our advocacy work now with implementation is to provide providers and patients with the correct information so they understand how the process works and how to go about it. And also to advocate that agencies, healthcare networks, and administrators, and any other policymaker should be honest and straightforward with patients, whether they support or oppose the law, so that patients can be clear about the policy and not be delayed in their efforts for access because they're not getting the information they need. We have encountered one or two instances where patients are simply being told nobody knows what's going on about it. And that causes the patient to have to hunt around and spend precious time trying to find the information they need in order to access the care that they want. And that's just not fair. So what I advocate also, I should be honest too. This is not. I don't mean to vilify providers or healthcare networks. Because the law is new, and because we don't have a lot of providers who are experienced with it, things do still feel a little up in the air from a provider perspective. And also, I do hear from patients who, for whatever reason, have fears about talking to their physician. So I had a patient who called and said, I've had this oncologist for 30 years. This person took care of my spouse before she died. She has taken care of me with 4 instances of cancer over the past 30 years, and I can't bear to ask her this question. And for fear of losing the friendship or the relationship. So the challenge is for patients to recognize they are consumers of healthcare, and to be willing to be honest about their decision and not be afraid to ask the question. And I've heard patients say, well, I asked my doctor how they felt about the Maine Death with Dignity Act. That's not the same thing as asking your physician if they will support you when you need it. So I advocate that you be very clear. Will you support my decision to access the Maine Death with Dignity Act by helping me qualify and by writing my prescription if and when I am qualified? Be that specific with your physician if this is something that you want to be considering for your end of life plans. And that gives your physician an opportunity to say either, yes, I'm in a network that supports that policy, and I personally support that as well. Or to say, look, I'm not morally aligned with this law. It would cause me discomfort to prescribe for you. And then you can have a further on conversation about how to get referred to someone who could help. The law does state that referring a patient to another physician is not an act of participation in the law. It doesn't mandate that a physician has to provide a referral to a physician who will help you, but it states that doing so is not an act of participation. The acts of participation are acting as the primary physician who would write the prescription after qualification, acting as the secondary physician who would confirm that diagnosis, acting as a pharmacist who would fill the prescription and dispense the medication, or acting as a care provider who would be in the room when the patient ingested their medication. So that's what participation is defined as in the law. And then there's a list of things that are not considered participation, and this patient referral is one of them. So with that, I will wrap up the nuts and bolts, and I really would prefer to open up for questions because I'm sure there's one or two of them. So let me close my screen share here. And just if you do need more detailed information, if you want to go to the Maine deathwithdignity.org website, and the national organization is deathwithdignity.org. They have tons more information on their website. And I will
Thank you, Val, very much for this wonderful presentation. It's very informative. I have not said this before, and I should have. If anyone has questions or comments, the best way to do so with Zoom is to use your chat function. And Sarah and I will keep an eye on the chat function. Now would be a good time if anybody who is tuned in has a question for Valerie. That can be typed in and we will present that to everybody else. Works better to do it that way than to have more than one person speaking at a time. Zoom doesn't cope well with multiple voices at the same time. So are there any comments or questions for Valerie?
Val, there were some questions in the chat while you were speaking. One is, didn't Maine Hospice Council not support Death with Dignity? Is that still true?
So the Maine Hospice Council, which is an educational organization, does not, is religiously opposed, is my understanding. The executive director simply is just not morally aligned to it. That being said, the Maine Hospice Council organization, which does not represent all hospice organization positions in the state. So it's important to keep that in mind. This does not mean that hospice doesn't agree with the law. It just means that the people on the board of the Maine Hospice Council and the executive director don't support it.
And there was also another question asking about if you were going to mention the Final Exit Network.
I actually was not going to mention the Final Exit Network, but I can speak a little bit to that organization. They are a separate entity. They are not affiliated with Death with Dignity laws. Final Exit Network is an organization that seeks to educate folks on ways they can end their life if they feel that is necessary. I guess that's called or considered rational suicide, where you're making a decision to not go on living for whatever reason, particularly, I guess, if your state doesn't have a law like Death with Dignity. Sadly, here in Maine, some of the research I did before our law was enacted showed me that the highest rate of suicide completion in the state is in the demographic of age 65 and over. In fact, one of our bill sponsors, Senator Marianne Moore from, I think she's Washington County, her testimony, what had changed her mind about this law was that she was a cancer patient navigator, and her role was to help patients get to and from their appointments and so forth. And she had an elderly patient who was supposed to show up for a breathing therapy session or something like that. And he didn't show, and they later found he drove a few miles down the road from his home and shot himself because he was just tired of being terminally ill, and he felt ready to go, and he felt he had no other options. So you can find the Final Exit Network website. I think it's finalexit.net, but it could be a .org. It's hard to say, but and just take a look at their information. Derek Humphrey was a man from Australia whose wife died many years ago, and he's the founder of that organization. I guess that's really, I'm not real schooled on how that all works, so I will leave it at that.
We also have in the chat from Doug. I'm not sure, Doug, if this is a question or if you're just letting Val know what you're doing, and if you'd like to unmute and explain.
No, it's really a question. I mean, Maine Medical Center, at least when I looked a year or so ago, did a pretty good job of providing information about end-of-life planning on there and the forms to fill out and so forth on the first page of their website. And to have that available on those websites, I think would be really helpful in terms of people figuring out how to access information if they didn't otherwise know how to do it. So I've been talking with Northern Light Health. I'm retired now, but a few years ago, talking with them about trying to get something on their website. I think they do have something now, but it's not particularly well featured.
I agree with you, Doug, and I advocate with these networks as well. One of the challenges that they face, and I'm not a hospital administrator, so to me that's a really big role. But because the law is so new, there is a hesitation among physicians and organizations that they don't necessarily want to be readily identified as the go-to guys for death with dignity. So they're
Right.
still really navigating this and finding their way with it and trying to develop a comfort level. And so I would love to see at least a public-facing policy on their websites as well that would help patients know we do support decisions. Here's how to have that conversation with your physician or something like that that would indicate to a consumer of healthcare that there's help there. I believe that Maine Health or Maine General Hospital may actually have something on their site as well.
Maine Health has done a pretty good job in terms of providing resources on end-of-life planning, advanced directives, and so forth. I don't know whether they mention death with dignity or not. That's more problematic, I'm sure, for a lot of these institutions.
It is, but I think they do mention it. And ultimately, I think there will be a greater comfort level to include that on their websites.
Yeah.